So for me, the next guest, who is sort of a guest and sort of not, is really a privilege, and I ask for the privilege of announcing and giving you an introduction to Joe Farley. Joe has been going to this church, started going to this church as a little boy. Deb and Jim Farley are his parents. Jim's been an elder for a long time. Wonderful friends, wonderful participants in this congregation. Joe has had a really interesting career so far, and that makes him, some of the things that he's got in his life makes him especially credible and knowledgeable and gives us a great privilege to hear what he has to say. We are not positing political stuff because that's not what we're here for. However, there are some things that are going on right now there's all kinds of, let's say, some strategery going on, and it's stuff that he will help inform you about based on some of the court decisions that have occurred in the not too distant past. Now, so why do we care what Joe Farley has to say about court decisions? Well, Joe Farley's got quite a bit of experience in that respect. Aside from being an engineer and having an MBA, he also has a JD, which is a Juris Doctor. He's done work on his LLB. Is that what it is, Joe? What is it? MLM. That's way above my pay grade. He is also a JAG officer. But more importantly, he's worked in our federal court system as a clerk for 3 different judges, I believe, 2 of whom were Court of Appeals judges, which means when you're in federal court, above the Court of Appeals judge is only a judge or court is the Supreme Court of the United States. He spent years in Washington, D.C., clerking for judges, and when you clerk for a judge, as a lawyer, I can tell you, that's not like you go fetch paper or something. They're required to be a lawyer. They're required to be a highly qualified lawyer. They're required to be a lawyer who is erudite in the law and accomplished academically, which he is. They're also required to contribute to the judge's opinions. Sometimes they write the opinions and the judge corrects them or changes them however they want it to be changed, or they tell them generally what they want them to do. They do the research for the judges, so the judge has the background of the cases and that have preceded this case and those cases that are cited by the appellants. It is a lofty position that he's been in times 3 in federal court judge positions. You don't get those easily. You get those because you understand the law and you know how to interpret it and advise the judge and present the judge with the things that he or she needs to know. That's a big deal. He is, let's see, what else do I need to talk about? He's licensed in Ohio and Washington, D.C. He currently works for Jones Day, which is an international law firm. They have offices all over the place. The office that he now works in is in the Columbus area. And he and his wife, Katie, and 5 kids live near Columbus, and they are active members of the Marysville Church of Christ. So Joe is first a Christian, but second, he is a really accomplished legal scholar in addition to being a practicing lawyer and an engineer. So let's give Joe, Jim, you can stay down. Let's give Joe an opportunity to help us understand some of the implications of the cases that have come up recently and how they affect how we behave towards our law and as far as how we respond to it and how it measures up against God's law.
I think there we go. Well, good evening. So we had Tindertown on the way in, so there may be a few Marco Rubio moments up here as I pause to take a drink. So thank you, Don. Thank you to the elders for giving me this opportunity. It was spurred on by a meeting that I had a few months ago with some other attorneys in Columbus. And to talk about some of the things we're going to talk about tonight. And I've always been very pro-life, been very convicted in that way. But they showed us a short, minute-long, maybe a few seconds longer than a minute-long clip of what an abortion looks like. And that lit a fire underneath me. And so it has been our goal up until the general election in November to try to talk about this topic because it is just such an important thing that we as Christians need to confront head on. I will say, like Don said, this isn't a political talk. Unfortunately, what we're going to be talking about tonight it is a political issue, but it is a religious and moral issue that has been politicized, right? So we should not feel ashamed as a church to talk about this issue. We shouldn't feel ashamed to talk about what the Bible says about this issue and how we as Christians should be convicted when it comes to what is now a political issue. That said, this isn't a political talk, but again, we should not be afraid to talk about this. We shouldn't be afraid to confront it head on. All right, so let's begin. Mike, maybe, there we go. Okay, so let's start at the beginning, or at least a point way back in the past, the 13th century. Now, one of the things that I want to accomplish before we get to what we're going to be voting on this fall is just sort of setting the groundwork, right? We often hear about abortion being a right that has been taken away from us, and history is often cited against us, and in particular the last 50 years of history is often cited against a pro-life view. But if we go back, starting with the 13th century in Europe, abortion was illegal, at least post-quickening. Quickening being the time when a woman could begin to feel the fetus, the baby moving. Now, they didn't pick that time because they were pro-abortion, pre-viability or pre-kicking, but it was just a matter of practicality. They could not tell, they didn't have the equipment, they didn't have the technology to know when a woman was pregnant. So abortion was illegal as far back as the 13th century. We go to the 19th century, in 1868 in particular, now we're in the United States, and 1868 is important, and we'll come back to that because 1868 is the year that we ratified the 14th Amendment. So that's significant. But as of 1868, abortion was illegal at all stages of pregnancy in 28 of 37 states. Moving forward into the 20th century, 1919, abortion is illegal in all 48 states. And then by 1960, 1 year after the last of the 50 states was entered into the Union, abortion is illegal in 46 of the 50 states, however and whenever performed. All right, so this isn't, two things we need to understand here. Abortion is not a fundamental right. It wasn't. And the other thing we need to understand is that it's always been a state issue. It's always been something that the legislature of the states could control. And the legislature being controlled by the people was something that the people could weigh in on. So each state controlled whether abortion was illegal or legal at the state level. All right, Mike, there we go. So in 1973, that's when we get Roe versus Wade. We're all very familiar with the name Roe versus Wade, but there's not really a good way to say it. I think this is the worst decision, maybe besides Dred Scott, that the Supreme Court has ever issued. It is a terrible opinion, and I don't say terrible just in that I didn't agree with the outcome. I say terrible in that it was based on so little law that it just made no sense. So the court in Roe said that abortion is a right, and what they did is they devised this right to privacy. You won't find the right to privacy in the Constitution. It's nowhere mentioned. It's just made up of whole cloth. And essentially what the court said is, and I think the word they use is penumbra, like the aura of the Constitution, just what it stands for. It has to include this certain set of privacy rights that we all get, right? We all, as U.S. citizens, have these rights. And they said that one of them is a right to privacy. And inside of that right to privacy is this right to an abortion. So in doing that, what they did is they stripped the states of the ability to regulate abortion and made it now a federal constitutional issue. So what it did and is subject state laws to a higher level of scrutiny than they had been subject to before. And the court set up this trimester framework where they said, okay, in the first trimester, a woman's, her interest in her own body actually are more important than the state's. And in the third trimester, when we're approaching the time for birth, the state's interest in protecting the child are more important than the woman's, and then that second trimester, we'll just sort of figure it out as we go. So they broke it up into trimesters. And the other thing that they did in this decision that was significant is they rejected outright the argument that an unborn child is a person entitled to protections under the U.S. Constitution. So that's Roe. And again, I want to make sure we understand that it took what was a state issue and made it now a federal issue and subjected it to not strict scrutiny, but a stricter scrutiny under the U.S. Constitution. Oh, looks like it's working. Oh, Mike, I think we're working against each other. There we go. Okay. So moving ahead just about 2 decades, we get Planned Parenthood v. Casey. And Casey sort of doubled down on, not sort of, it did double down on Roe. And so they upheld Roe. And more than that, they now said that it's a fundamental right. This right to abortion is a fundamental right that is part of the due process clause of the 14th Amendment. So remember I said a few minutes ago we're going to come back to 1868. Well, what the court was saying in Planned Parenthood was when the states ratified the 14th Amendment, within that 14th Amendment was subsumed a federal right to abortion. But remember, I told you that 28 of 37 states made abortion illegal at the same time. So they tied themselves in knots here. And Justice Alito called them out for this later, but they even acknowledged this was a plurality decision, meaning that there wasn't a majority of justices that agreed, but there was a plurality that said, look, we're going to uphold Roe's central holding, that idea of abortion being a right, but we don't really agree with it. But because of this thing called stare decisis, which means we just got to we got to defer to what we've done in the past, they upheld Roe. And it was really interesting, but they cited a need for predictability and consistency in the court. And the last thing that they did that I found significant is they replaced the rigid trimester framework with one of undue burden. And so what they said is a state cannot unduly burden a woman's right to an abortion. Nobody really knew what that meant then, and quite frankly, depending on the judge that you were in front of in federal court, it could mean different things. So it was really an opaque standard that was very malleable in the right attorney's hands. So then we get to 2022, and this is Dobbs, and I'm sure we've all heard of Dobbs, but this was written by Justice Alito, who I think probably gets it right 99% of the time. He's probably my favorite justice, but Dobbs overruled Roe, and they essentially called the court out for what they had done in 1973. They said this was just made up of whole cloth. There's nothing in the Constitution that gives American citizens a right to an abortion. And so what Justice Alito and the majority did is they said it is a state issue. It's always up until 1973 been a state issue, and it's going to go back to the states. It doesn't mean that abortion is legal everywhere. It doesn't mean it's illegal. What it means is that it is up to the citizenry of the states to determine how their state is going to either make abortion illegal or legal. And the other thing it did is, you're going to hear this idea of levels of scrutiny, but it subjects state laws to a lower level of scrutiny at the federal level. So you can still challenge abortion laws, state laws, in federal court, and you can challenge them on a constitutional ground. It's just that they're subject to what we refer to as rational basis, which is a very low level of scrutiny. So anyway, that was Dobbs. And again, the big takeaway from Dobbs is all that Dobbs did is take what was a state issue up until 1973 and kick it back to the states. It's essentially put us back into the status quo of 1972. Okay. Now, this number is staggering. more than 64 million babies were aborted between 1973 and 2022 when Dobbs was issued. And that is a number that can go in one ear and out the other, and it just passes us by. And I don't know how to make that number real to you, but I looked it up. That would be 875,000 fully loaded school buses of children that would have to pass by this church before we hit that number. 875,000 is a number that we can't fathom either. So I'm going to have to read this, but all the people in Arizona, Washington, Colorado, Oregon, Idaho, Utah, Montana, Wyoming, Nevada, New Mexico, North Dakota, South Dakota, Nebraska, Oklahoma, Minnesota, Iowa, Missouri, Arkansas, and West Virginia could disappear in a cataclysmic event, and that would be right around 64 million people. It is a huge number of babies that were murdered in that time. So, Dobbs comes and goes, and when Dobbs overturns Roe, states, particularly conservative states, had put into place what were referred to as trigger laws. And these laws were triggered by the overruling of Roe. And a lot of them made abortion illegal at the point of conception. Some would pick 6 weeks, 15 weeks, whatever it may be, but it triggered all these laws. A lot of them have been enjoined, which just means there's a pause on the law. But that's one thing that happened. The other thing that happened, and the thing that is important to us this evening, is the pro-abortion lobby has now moved on to a different tact, right? So what they're doing now is they're going into states and they are funneling money into states to try to amend the state constitutions to include a right to abortion. This happened in Michigan, right? And Michigan is not, I would say, politically conservative, but I think that on social issues, they may match up with us much more than we think. That with Ohio, I speak generally, but it passed in Michigan, and we'll talk about why it might have passed here in just a second. So in Ohio, the current state of the law is somewhat in flux. In 2019, the legislature passed and the governor signed a heartbeat bill, which effectively banned abortion at the 6-week mark. The first indication of cardiac rhythm, abortion is off the table, except for in situations for medical emergencies with respect to the mother. In 2022, a judge in Hamilton County enjoined that law, so again, paused it. So that law is not in effect right now as that Hamilton County case works its way up through the state courts. The law is a little bit unclear now because there is a statute that says that abortion in Ohio is illegal after 20 weeks. But then the judge references 22 weeks in the opinion. So it's in flux, but 20 or 22 weeks is where we're sitting right now. In fact, Governor DeWine recently came out and said, we need to clarify this, right? There's some confusion. What is the law in Ohio? Now, that gets us to what I want to talk to, a big chunk of what I want to talk to you about tonight. So the first thing is issue 1. You may have seen the signs or the commercials, but issue 1 is something that we as Ohioans are voting on right now. The mail-in voting is ongoing, and so is early in-person voting. But issue 1 concerns the stability of the Ohio Constitution. And at present, Ohio requires a bare majority, just a simple 50% plus 1 majority to amend their constitution. Ohio, I was checking the other night, it's one of the lowest thresholds for amending the Constitution. I think it may very well be the lowest. Most require 60, 67%, or even 3/4 of the people to amend the Constitution. Ohio requires 50% plus 1. Now, 50% of Ohioans is a big number. The problem is that when we have these special elections, a very small number of people show up. So in a given special election, you may have 25 or 30% of registered voters actually show up. And 50% of 25 is just 12.5%. So if we have 12.5% plus 1, we can amend the Constitution. That's sort of I think, I forget the word that Don used, but maybe gamesmanship is what comes to my mind. Sort of playing games, right? Making this a special election. And so in any event, it's very important that everyone try to get out to vote for this. Now, One of the other things that is a problem is that these out-of-state interest groups will pick and choose which counties they want to put money into depending on the politics of the particular county. So you may see a lot of money funneled into counties that surround cities, right? So you can imagine a situation where you're amending the Ohio Constitution, very few people are paying attention, let alone voting, and a very small number of similarly minded people are voting to amend the Constitution for all of us. So this is something that we really have to pay attention to. So issue 1 does a couple things, does a few more things than this, but a couple that I think are very important. One, it increases the threshold for amending the Constitution from 50% to 60%, which still puts us in one of the lower requirements with respect to percentage of voters to amend the Constitution. It's not terribly high, 60%, but it does give us that extra 10%. And I was explaining this to somebody at another church the other day. 60% seems to make sense to me because usually you have about a 45-45 in the political parties and then you have 10 independent. It means that for an amendment to pass, you've got to have almost everybody in one party, all the independents, and you've got to convince some people who usually don't agree with you, right? So I think 60% it's a start, right? And it's a good step in the right direction. The other thing that it does is it requires these outside interest groups to get signatures from every county, 5% of the voters in every county before an amendment goes onto the ballot. Right now, you only have to do that in half the counties. So you can imagine, again, they're going to be picking and choosing counties based on politics. So this makes, I think, the Ohio Constitution more durable. It makes it more stable. So anyway, you can kind of see where I'm leaning on issue 1. But a yes vote on issue 1 will protect Ohio's Constitution. It's going to make it more stable. It will, again, insulate it from that sort of chicanery that may be going on. A no vote will maintain that status quo, keep it at 50%, and again, only having to get signatures in half the counties. Okay, important dates for issue 1. July 11th has already come and gone, but that's when absentee and early in-person voting started, so it is ongoing. And then August 8th is the special election, okay? Now, that all leads up to the pro-abortion amendment that is not on the November ballot yet. They have until tomorrow to count signatures. The groups think that they have the number of signatures. They probably do, but the Secretary of State has until tomorrow to certify those signatures. If they get the 413,000 odd number of votes or signatures that they need, it will go on the ballot in November. We don't know what the language of the ballot's going to be, so I can't tell you what a yes means. I can't tell you what a no means yet, but in all likelihood, this will be on the ballot in November, so we need to be paying attention. We're going to look at the language of the proposed amendment here in just a second. But before we do, I want to talk about a couple of myths that I think you're going to be hearing, if you haven't already heard it, between now and November 11th. So the first myth is that without this amendment, women's lives are going to be at risk. And you need to understand that in Ohio, it has always been and will always be an exception. There will always be an exception for the mother's life. Women's lives are not in danger under the heartbeat bill or any other bill that Ohio has ever had. Right? There's always an exception for the life of the mother. The other myth that you may hear about is I think it's just a scare tactic, another one, but this idea that without this amendment, women will not have access to proper miscarriage care. Again, that has never been the case. It will not be the case. Miscarriages are something wholly different, and they are not illegal. There is nothing about the heartbeat bill or any other bill that Ohio has that makes miscarriages illegal or in any way hampers a woman's ability to go seek care in case of a miscarriage. So let's look at the language of the amendment. Dad, did you hand those slides out? Or you don't. If not, it's not a big deal. You don't have to. But so, what's that? Okay. So I'm going to walk through it piece by piece, but I've got some stuff bolded and underlined because I want to talk about this in particular. And Don and Dan are probably looking at it, maybe having some of the same sorts of reactions that I am as I read it. But we'll just start, and I'll read it word for word, and then we'll talk about it. So it says, oh, and first thing, let me give you the name of the bill real quick. So it's called The Right to Reproductive Freedom with Protections for Health and Safety. So abortion isn't mentioned in it, but it's the right to reproductive freedom. And that's going to be important here in just a second. So it says, every individual has a right to make and carry out one's own reproductive decisions. Now, I underlined individual because you'll notice it doesn't say adult. So this opens the door for minors to have access to abortions without parental notification or parental consent. So when they say an individual, again, there is no mention of adults in here. Then it says, including but not limited to decisions on, and this part is particularly scary as well. When it says including but not limited to, and it's referring to the reproductive decisions, right now we're all dealing with a lot of the transgender issues. Well, certainly a reproductive decision, including but not limited to, this list of things would include a minor's decision about their own reproductive parts, right? So, and I'm going back to the title. The title doesn't say abortion, it says reproductive freedom. So we have to be wary that this opens the door not just to the idea of an abortion, but so many other decisions that concern reproduction, right? So then it lists contraception, fertility treatment, continuing one's own pregnancy, miscarriage care, and abortion. The only one of those four things there that Ohio has made illegal is the abortion. I think the inclusion of the other four is just a scare tactic, right? There's nothing in Ohio that is making it illegal to take birth control or in any other way stop from becoming pregnant, right? Contraception, the fertility treatment, I'm not aware of any law there either, or continuing your pregnancy. The same with miscarriage management, right? There's nothing there. I truly think this is all just in as part of a scare tactic. Moving on, it says, the state shall not directly or indirectly burden, penalize, prohibit, interfere with, or discriminate against either. I underline burden because that gets back to the standard we saw in Casey. And again, burden just means whatever a particular judge wants it to mean, right? It's certainly there's going to be a spectrum that has been set out by the appellate courts and the Supreme Court, but burden can mean different things to anybody. So what does burden mean? It's really hard to tell. An individual's voluntary exercise of this right, or a person or entity that assists an individual exercising this right. In Hamilton County, I think it was last year, you had a 22-year-old soccer coach who was raping a 14-year-old on his team, then assisted her with having an abortion without her parents' knowledge. Now, he's in jail because under current law, that's illegal, but certainly a person that assists somebody else in having an abortion has a really good argument under this that they have a right to do so. Unless the state demonstrates that it is using the least restrictive means to advance the individual's health in accordance with widely accepted and evidence-based standards of care. I underline least restrictive means because you heard me mention scrutiny earlier. Least restrictive means is the highest level of scrutiny that the courts apply. It is something called strict scrutiny. So we have strict scrutiny, intermediate scrutiny, rational basis. I mentioned rational basis earlier. That's what Dobbs kicked us back into. Least restrictive means is the highest level of scrutiny, which means that the state law has to pass this highest level of scrutiny in order to be constitutional. It says, however, abortion may be prohibited after fetal viability, but in no case may such an abortion be prohibited if in the professional judgment of the pregnant patient's treating physician, it is necessary to protect the pregnant person's life or health, patient's life or health. Now, two things here. We're looking at the treating physician's opinion, right? Who is the treating physician going to be? It's going to be an abortionist. It's going to be somebody whose income is based on the number of abortions that they perform. And the other thing there is that the decision is based on the life or health of the mother as determined by that doctor. But health, under Ohio law, doesn't mean what we all think it means. It doesn't mean our physical well-being. It includes financial well-being as well as emotional, right? So if you can convince a doctor who is financially incentivized to perform an abortion that it is both in your financial and or emotional interest to not be pregnant, when you're 8 months and 3 weeks pregnant, you can have the abortion, right? That's what this law does. It opens the door up to full-term abortions. Lastly, it says fetal viability means the point in a pregnancy when, in the professional judgment of the pregnant patient's treating physician, again, that abortionist doctor, the fetus has a significant likelihood of survival outside the uterus with reasonable measures. This is determined on a case-by-case basis. This amendment does not set out any standard. Rather, the standard is controlled by these doctors on a case-by-case basis, considering the health, which again includes financial and emotional well-being of the mother. Lastly, state includes any government entity and any political subdivision, right? So if you were to read this, it doesn't seem all that bad at first blush, but it is opening the door to so many things that I don't think the typical Ohioan quite understands, all right? And that's what I wanted to impress on you with this. Again, this isn't on the ballot yet. We may know tomorrow, maybe the end of this week, whether it will be. I fully expect that it will. But pay attention because it's likely something that you're going to be voting on. Now, the important dates for this amendment, October 10th is the deadline to register to vote. October 11th, absentee and early in-person voting begins, and then November 11th is the general election. Okay. I'll take some questions if there are any. I will say that I have a bit more to talk about if we have time. But if anybody has questions that they think would be helpful to the group, I'm more than happy to take them. Mark.
Thank you, Joe. Just to clarify, there are two issues that we are being asked to vote on.
Yep.
One is August 8th, and that changes the limits on passing a constitutional.
Yep.
And on that one, we want, you would be saying yes.
Exactly. So what Mark asked, for those who are listening online, is are there two issues? And I apologize if I wasn't clear, but yes, you're exactly right. Currently, there's issue one. Issue one is the change to the Constitution that, again, I think makes the Constitution more stable, right? We're increasing that requirement up to 60%. We're requiring signatures from every county, right? So that's issue one. That's what we're voting on now up through August 8th. The second issue, we don't know if it's an issue yet. Very likely it will be, but that is this amendment to the Constitution that concerns abortion, or as they've put it, reproductive freedom. Yes, Hal?
Hey, Joe. So issue one, it's only applicable, the 60% is only applicable to proposed amendments to the Ohio Constitution. Other items on the ballot will still be a simple majority.
Yeah, that's right. So all that issue one affects is the ability to amend the Constitution. It doesn't change the requirements, you won't see it come 2024 with the presidential, it won't be that it requires 60% for the electors of our state to pick a president, right? It only affects amending the Constitution, right? Phil.
Would the abortion proposal still be valid because it's approved before the election?
Yeah.
There's changes around the percentage of signatures and where it happens if issue one passes. Because it predates that, it would still apply.
Yes, it would. So even if issue one passes, let's assume that they have the number of signatures. If issue one passes, that measure, the abortion amendment, will still be on regardless of where they got the signatures and how. Yeah. That's right. It's just going to kick it up to that 60% threshold. Yes?
You referenced earlier the 14th Amendment, and I may be the only one here who doesn't remember her history, but what is the 14th Amendment?
Yeah. So in short form, so after the Civil War, we passed some amendments that took the Bill of Rights. I'm going to get too deep in the history, but so the Bill of Rights was a check on the federal government, right? The states originally were not subject to the Bill of Rights, right? And I think a lot of people forget that. What the 14th Amendment did is it said, okay, states, if you're going to act in a nefarious way like the southern states were, we're going to amend the Constitution such that you're subject to the same rules that the federal government plays by, right? So the 14th Amendment took some, not all, and the Supreme Court has spliced it up, but the 14th Amendment took some, but not all of the Bill of Rights and said, states, you got to play by the same rules. All right. Oh, yes.
I'm confused because I heard an advertisement
Yep.
that was in favor of voting yes on issue one.
Mm-hmm.
And it says, if you don't vote for this, we will lose our right of one person, one vote.
Yeah.
Will change to some other way, like you vote for a representative who works for you, but obviously it was just a quick little commercial type thing and not reading the details, and I hadn't read all the details you just presented. But, so, my first reaction to that was, oh yes, then we want that, because we don't want to lose my right, one person, one vote.
Yeah, so Don and I were talking earlier, and he referenced, I believe, the same commercial. That's not a commercial that I've seen. I'm not saying games aren't played on both sides, right? So I'm sure that they're trying to scare you a little bit. But I don't quite understand the argument they're making with you're going to lose your one, the one vote per person. I don't quite understand that. I don't know. Katie tried to pull the video up. I don't know if she ever did, but maybe if I watched it, I could explain it a little bit better. But voting yes on issue one will bump it up to that 60%. And yeah, I don't understand the commercial. Yeah,
More
yeah.
attractive to me. It's just I didn't want to lose my vote if someone represents.
Yeah, I'll have to watch it.
Like
Yeah,
I say, I just hear all the details.
yeah. Done.
It's just a way of spinning it. It kind of depends on whose auction's being bored and how you tell the story. And you're not necessarily lying, but you've got to hold your head at a certain angle before you can see it that way. And so, bottom line is, if the majority rules and majority, one, let's say, portion of the state hardly shows up, then the idea is to make it more difficult to change the Constitution so we have a more stable government. And right now our Constitution is such that a simple majority, that is more than 50% of a given election, which could be, I've been voting for 50 years. I've never heard of an August election. And I don't remember one. There might have been one slipped in there somewhere, but that's not when we have elections. It's a Tuesday in November. That's when we have elections, and everybody's figuring that's election day. And people get off work for election day often, or at least time to go. So let's have it on an odd day where we think the majority of people won't come. And then let's really hit the areas that tend to be concentrated in the people who agree with the issue that we want to pass. Let's hit them real hard and make sure they show up. Or even we'll send them ballots and make sure they mail those ballots in within the prescribed time. And it's nowhere near a majority of the people in the state, but it's a majority who shows up on August 8th.
And that's what it is, the majority of the people who vote.
That's exactly right. And the issue one, it does two things, and correct me if I'm wrong, Joe, because Joe studied this, I'm sure more than I have, but it does two primary things, it does several things, but two primary things. One is it raises the standard from 50 to 60%. Two, it also raises the standard that you have to have a minimal percentage from each jurisdiction.
Yeah. Yeah, that's right. So as I mentioned earlier, it requires 5%. The issue one, if it passes, would go from requiring a 5% of the signatures in each county to requiring 5% of signatures in every county across the state. So you can't just pick and choose your counties depending on who agrees with your issue. You've actually got to get everybody on the same page that, hey, this might be a good idea, so let's pursue it. But
So that's where you get the argument that maybe the one vote, one person gets one vote or something like that. I mean, they're trying to say that it somehow convolutes your ability to vote. Well, what it does is it just raises the standard, the Constitution more stable, and makes it a little more difficult to change our full Constitution.
if anybody has any other questions, we'll be here afterward. We don't have far to drive, so. Okay, so real quick, I'm going to move on for just a second. It's probably an hour worth of slides that I'm going to try to do in about 10 minutes. I won't do it justice, but I think it's important. We need to be ready, right? The idea behind some of this is, it isn't to condemn anybody. It is to equip and educate us to be able to talk to people about this issue, right? So in my mind, and this is all my mind, so it's a bit scary, but in my mind, there are two ways to defend a pro-life view. There's the secular way of looking at it, and then there's the Bible, right? And a secular view only gets you so far, right? Science, right? They say science, science, science. Well, science tells us that at the point of conception, your physical identity is established, right? The DNA for a baby is established right then and there. But that only begs the question of when does life begin, right? And when does life begin is a moral philosophical issue, right? It doesn't depend on science, it depends on your morals. And I think we as Christians need to be prepared to make a biblical argument for the pro-life view. Now, in order to convince somebody of the biblical view, they have to have true Christian theology, right? 63% of Americans claim to be Christian, but only 37% think that abortion should be illegal. And we have politicians that, and this is a person who claims to be a devout Catholic, say it's not about religion, it's about choice, right? And so when we strip this idea of abortion from religion, what are we left with? You're just left with relative morality, right? Moral relativity. And to me, abortion is a symptom of a fallen world. It is a symptom of something much deeper, a lack of Christianity in our world. Abortion is the symptom. And so when we talk to people, we have to understand that we can try to convince them of pro-life ideas, but down deeper, we also have to introduce them to the Bible, right? We have to establish that biblical foundation first. Now, that said, there's a lot of biblical arguments that get bandied around, right? So some people say the Bible says nothing about abortion, right? And it's kind of a silly argument. It doesn't say anything about, drowning puppies, but nobody would think that's a good thing to do, right? The other argument is the golden rule, right? I don't want somebody to tell me what to do, so I'm not going to tell them what to do with their body, right? I could say, I don't mind if you steal from me, so I'm going to steal from you. And this idea of do not judge, that one gets thrown around so much. It's used against Christians. It's terrible. The Bible does not say do not judge. It says judge in the right way. Judge based on the biblical standards. Do not do it hypocritically. Be discerning, right? So don't fall prey to these arguments, okay? We know that murder is a sin. It's beyond dispute, right? There is no argument. Murder is a sin. And murder is an interesting sin. And all sin is bad, but I do think that not all sin is the same, right? I think that murder is a sin against God. When I was a little boy, my older brother James used to spend hours building these farms, these intricate farms with his animals. And then I would wait till he was done patiently, and then when he left the room, I'd destroy them. And it was a sin, not only against that farm that I destroyed, but a sin against James, because James had spent that time on something that was precious to him, right? I destroyed his creation. And we have to understand that murder is a sin against the person, but it's also a sin against God, because we're not just killing that person, we are killing a unique creation of God's. And all of us, every one of us, is divinely valuable, meaning that we don't have to have somebody tell us we're valuable. We are valuable just because God made us. We are divinely valuable, right? Now, murder's bad. But murder also sort of has levels in the Bible. It's interesting. God hates murder of the innocent. We're told that. He hates innocent bloodshed, okay? And we're also told that God hates children being murdered, right? The Bible tells us it's detestable. It was one of the sins that the Canaanites were participating in that God said, I don't want that. You are to set yourselves apart. It is a detestable practice. It is abominable. It is despicable. The murder of children is something that God hates. In fact, he says that he will turn his own face against them when they do that. Now, that sort of, again, begs the question of, well, I can tell somebody all these things that I've just said to you, and they aren't going to disagree, right? I don't think. As long as we have that biblical foundation, I don't think anybody can disagree, because all of that is based on Scripture. But then, again, it begs the question of, when does life begin? Right? Are unborn children to God? And I'm telling you, they are. It is undoubtedly, like there's just no dispute, right? God says, I knew you before I formed you. God, the pronoun, like he says, I formed you, right? He forms each one of us. The point at which we are born is not the trigger that takes us from being something, this clump of cells that God cares nothing about to being this precious being. God tells us that it starts from the very beginning. When we are in the womb, we are precious to God. We, again, are divinely valuable, and so are unborn children. Now, this is a neat point, and it's frankly a bit of a nuanced point, not one that I had thought about, but we often hear this idea of like, my body, my choice, right? The baby isn't a baby. It doesn't itself have personhood. It's not individual because it's in me, so it is actually me, and I can control my body. And again, the Bible doesn't explicitly say that that's wrong, but it impliedly does so over and over. So in Genesis, Rebekah is told that there are 2 nations in your womb, right? And in Judges, angel comes down and tells Samson's mother that she is not to participate in drinking wine, right? Not because she wasn't to be drunk, but because the child inside of her was already set apart before birth to be a Nazirite. He was set apart in the womb. It wasn't the mother, it was Samson that was set apart. And then in Luke, it's this, after researching for this, this story has taken on just amazing meaning. In Luke, we hear about Elizabeth pregnant with John and Mary pregnant with Jesus coming together. And John, upon Mary entering the house, leaps for joy inside of Elizabeth's stomach, right? So we have John, who is reacting independent of his mother to the presence of the Messiah, independent of Mary, right? So this idea of personhood is confirmed over and over in the Bible by the stories that we hear. And the last thing I'll say is we don't need a scripture to tell us that things are wrong, right? Go back to Genesis and we have Cain and Abel, right? Cain murders Abel and God comes down and he says, what have you done? And your brother's blood cries out to me from the ground. And Cain is condemned and punished by God. But it's not because murder being a sin was written down on stone or papyrus or paper anywhere. It's because murder being a sin was written on Cain's heart. He just knew it. He should have known it. He did know it, right? So God has imbued us as humans. This is what sets us apart from all the other creations of God. We have a conscience, right? We have the ability to know what is right or wrong just by our very being. Now, our conscience becomes polluted, and in the New Testament, Paul talks about that, right? Our conscience becomes polluted to where a great teacher here at Withensville told me once, garbage in, garbage out. And so if we let garbage in, garbage comes out, right? We can make our conscience calloused. But a biblical conscience, one that is clean, knows that this is a sin, right? And in Romans, it's really interesting because God says, even to the Gentiles, those who have not heard of me, they know of my very being because I make it plain to them. They look outside, they see all the things around, and they should know me. They do know me if they would only let themselves know me, right? And that's what, again, in Romans, we're told that the law is written on people's hearts, right? So that's where I'll stop for tonight. I think we're just a minute before we should end. But again, I thank the elders for letting me share this. I hope some of this was helpful. And why don't we just dismiss in prayer real quick. Lord, thank you so much for the opportunity that we have here tonight to talk about this issue of unborn children. And protecting them, and thank you for the opportunity that we have to vote on this issue. Be with us and let your will be done through these next 2 elections. But again, we want to protect those who are the most innocent and defenseless among us, and that's unborn children. And we thank you for sending your son as an unborn child at first, and his death on the cross that gives us all an opportunity to be together with you. In his name we pray, amen.